For our meeting tonight, we're basically focusing on the, first of all, let's call to order. It is Monday, May 20th. It's our May monthly meeting of the East Norwalk Neighborhood Association, and I'm Diane Cece. For tonight, we'll be primarily focusing on the Norden Place Transportation Maintenance Terminal public hearing continuance, which is this Wednesday. And I just want to remind folks to check your emails. We did send out a flyer regarding the enforcement open house and forum that the city is hosting on May 30th. It will be at City Hall in the community room. Their presentation portion of it only will be via Zoom, and the open house will actually take place in person in the community room. And this will be presentation, Q&A, and dialogue with all the enforcement agencies within the city. So talking about zoning, building, health, fire, police, etc. All that have enforcement for a lot of the quality of life issues that have been of great concern and topic lately. So we encourage people to participate one way or the other in that event coming up. We don't have any guest speakers tonight. We'll be talking about current business at next month's meeting. And we haven't confirmed this yet, though, but we may have a couple of folks from our Norwalk Police Department. They may or may not be on tonight, just to observe and join us to talk about community services, community policing, their behavioral unit, which is relatively new. And we hope to be able to welcome them to either June or July meeting coming up. Okay, so I'm hoping that most of the folks who are on this Zoom tonight have already familiarized themselves with the Norden Place application. If you haven't, I urge you to go to do two things. Backtrack through the East Norwalk Neighborhood Association emails of the last few months. But also I want to remind you that all the documents that are associated with this application are available on the city website. And it can be a little confusing to navigate it. So if you want to scratch this down, again, but it's also in our emails, to view the documents, and we highly recommend that you do that. Some of them will make your eyes glaze over, but most of them are relatively eye-opening, to say the least. But to see those documents, you'll want to go to norwalkct.gov, then click to the Planning and Zoning Department under a city government, then find the link that has pending applications, and then click on the application for 10 Norden Place. And you'll actually see the application name as Norden Center LLC, because they actually own the property and they're actually applying to use the site as a transportation maintenance terminal. Although in the press and at meetings, you will often hear this referred to as the MTA or Metro North Railroad application. Though they would be the intended use of the property, the actual application is the applicant is the owner of the property. So don't be confused when you see that there. Okay, so Norden Place is a site plan review for a transportation maintenance facility. And basically what they're looking to do is use it for the Metropolitan Transportation Authority for work that's done in conjunction with the Metro North Railroad line, which is the New Haven, Danbury, New Canaan, I'm not sure if there's one more, for maintenance on those lines for rail track, drainage, etc. This is not a maintenance terminal that you may be familiar with that deals with the maintenance of actual rail cars. That's an entirely different division of the MTA. In addition to having maintenance on site within the Norden facility for things like plumbing, electrical, carpentry, and welding, they also intend to have several 100,000 square feet that's used for storage of rail materials and drainage, pipes, logs, steel materials, etc. And the facility will also be used as a dispatch unit for approximately 130 employees who would come in the morning, get their assignments, be assigned to a Metro North vehicle of some type, either a single operator or grouped together on trucks or equipment, or on shuttle buses. They would leave from there and go out to the various Metro North railroad and track sites to work, and then the whole same thing in reverse at the end of the day. Coming back into the facility, storing the trucks, dealing with any equipment or materials that they took with them, and then leaving in their personal vehicles. This is a site plan review and not a special permit, just to remind you. A site plan review, under a site plan review under the Connecticut state statutes, a zoning commission is legally obligated to approve the site plan if the application itself meets with the zoning regulations. They have no discretion regarding the operation itself, the use, or any impact, or just whether they feel that it's something that's good for the community or not. Those are the types of discretion they have under a special permit. But for whatever reason happened in the past 2 years, city staff decided to put in this new use, and they decided to designate it as a site plan and not a special permit. Also, under a site plan review, there's no obligation of the commission to hold a public hearing, but due to the controversy surrounding this particular parcel, and what many of you know that we all went through 2 years ago, with the same applicants actually applying for a massive warehouse distribution center. The city and the commission recognize that this is a controversial site. There's great public interest in it, and that the public would want to be heard. And they decided to go ahead and use their discretion to schedule public hearings. In fact, Wednesday night will be the third continuation of the public hearing. Under a site plan review, because they're not legally obligated to they have no legal authority to deny the application if it meets all the zoning regulations. So the first question we look at is, well, does it? And so generally communities make an assumption that planning and zoning staff would have thoroughly vetted any application, and before they advance it to a full commission, they would have made sure that the application itself met all the technical requirements. Having said that, sometimes things get missed and some things get interpreted in a different way than the public would interpret them. And sometimes things get interpreted in a different way than the court system would interpret that. I'll say a little bit about that in a minute here. Now, what the commission can consider, though, there are just several items within a site plan review that they can consider in terms of the potential impact on the community. The two that specifically apply to this application would be the category called stable traffic, and the other category that basically falls into environmental. We've posted these in our emails, but if people aren't familiar with them, I'm happy to send those out again before Wednesday so you can take a look at them. The question here then is whether this application would have negative impact that outweighs the benefits to the community. And so the question everyone will be asking is, well, do they? So that's something that the community can weigh in on, that's outside of the technical compliance of the application itself. And so when you look at what the real impacts are that could persuade a denial, and in this case, it should be no surprise to anyone that based on community feedback, what we know of the parcel and what we know of this application, that ENNA is representing the community. Sorry about that. Representing the community in opposition to this application. So what it boils down to in terms of the impacts that could persuade a denial, or something that could actually convince the commission that this should at least be what we call denied without prejudice, meaning they can deny the application as was presented, but leave it open for the applicant to make specific changes and come back and represent the application without having to start the process literally all over again. So these are actually, if there's a technical flaw that's found in the application where it clearly doesn't meet a regulation, there are some considerations of that we're looking at right now, based on the fact that this application was applied for as a site plan under something called Transportation Maintenance Facility. That particular use did not exist before 2022. It was created, for all intent and purposes, out of thin air shortly after the prior application for the massive warehouse distribution center was withdrawn by these applicants. It didn't exist in the prior zoning regs, and coincidentally, it doesn't exist in the regs that just went into effect on February 19th. So it only existed for a short period of time. Reasonable people would conclude that it was added in anticipation of this application. And so the applicants made a deadline to be able to file under the requirements that were approved in 2022 or the end of 2023 to fall into this category. There's a number of questions that we have and that our attorney has regarding the definition of transportation maintenance facility, because the city chose not to include a definition of transportation maintenance facility in either the regulations that they added this to, or to provide us with a definition of it that they are using to consider this application. Whereas there are other uses, things like contractor storage yards and other industrial uses, that this type of operation would probably more closely fit, and those operations would have required a complete special permit review. So it's just something interesting for folks to note about kind of how this thing came into existence, and that in fact it doesn't, for whatever it's worth in terms of convincing the commission that this thing should go back to the drawing board, or potentially convincing maybe something on a future appeal if that were to come about, that this thing never kind of passed the sniff test here in terms of the application itself and when it was filed and what they're looking to use this for. The second thing that would have an impact in terms of persuading a denial outside of a technical flaw or in addition to it is expert testimony that refutes the testimony that was provided by the applicant. In the case of East Norwalk Neighborhood Association, we chose to, on your behalf, to hire two experts, one a civil engineer who has a PhD in engineering and in environmental air quality, and or I'm not sure if that's what her PhD is, but she has a PhD, and to do an air quality review and compare it to the environmental impact statement that was provided by the applicants. We also hired a traffic planning expert from an engineering firm, from a large engineering firm, to do a review of both the initial traffic impact study that was presented by the applicants, and also to review the third-party traffic review that the city required be done. That third-party review is paid for by the applicant, but the engineering firm that does it is actually chosen by the city. So it's presumably not to be a biased review there. So the opportunity that we have, because of these are the two main mitigating factors regarding this application, are then to have our own reviews done, and if the results are that our experts conclude something different and refute either the methodology that their experts used or the actual conclusions that they came to, then we can submit those into the commission. And that's exactly what we did last week. Even as we speak, I believe at least the air quality civil engineer is also preparing additional documentation to rebut their subsequent response to us. And then the third thing that the commission can take into account regarding two aspects here that we can speak to is resident testimony as to the current and future impact on the community. And so there's differing legal cases and opinions about what the weight is, if any, of how a commission can view the actual feedback, observations, and experience of the public that this would impact. But I can certainly say in the case of this commission, it is something, the reason why they're holding the public hearing is because they do want to hear from the public in terms of what you think this will mean to the community. Either if you think it would be something that's beneficial and the reasons why it should be located here in Norwalk, even though it serves a regional purpose for the transportation industry, or if it's something that you think will have negative impacts on the community, and specifically for you to speak to those. And rather than in general, to speak to specifically the two items that we know that they can consider discretion, whether to, I'm going to say discretion in air quotes, in whatever discretion they do have in terms of a denial for this based on traffic impact and based on air and noise pollution. So at this point now, with the third continuation of the public hearing, basically what's going to happen on Wednesday night is, because last week's hearing went particularly late, and there were a number of people from the public who still hadn't had an opportunity to speak, and the applicants themselves get the final word, so they need to have an opportunity to rebut everything that we say and that experts say, and also make not closing arguments, but to make a closing statement to the commission on why they feel that this application legally should be approved. And so Wednesday night, the intent then is to reopen the public hearing for the purpose of hearing from the additional public who hadn't had an opportunity to speak. If you spoke at one of the other two hearings, then you can't speak again. That's under the regulations. However, if you have additional comments, either that you forgot to mention or that you'd like to bring up now based on the new information that you may have reviewed over the past week, you certainly can email that information in to the commission. Also, if you haven't already done so, whether or not you can appear at the public hearing, you can also submit your written comments in as well. Those comments go directly to the commission, and they also get shared with the applicant, and they also get posted on the city website, just so that you're aware. As a reminder, all communication to the commission must go through staff. We can't communicate with them directly, especially once the public hearing is active. And so you send your communications to the commission, but in care of Director Steve Kleppen at skleppen@norwalkct.gov. And that's also on the city website, and we also have that in all of our emails as well. So this is what our advice is to the community. First of all, I want to commend some of you. I know that are on this call, and I'm not going to call you out by name because I don't like to do that to people, but there are a number of people who really have been doing a great amount of due diligence on their own to take a look at this application, take a look at the history of the parcel, consider what the impact would be on the community from their point of view, and also raise some very valid questions about why this application is being considered at all, but also raising valid questions about the type of materials that were presented by the applicant and their attorney. And so a lot of times people will just send that into ENNA kind of, more as a sanity check. What we encourage you to do is, if we take a look at it and we don't find something kind of like a showstopper to say, oh no, that's not the case at all, or it's inaccurate, and we would let you know. But if it's something that we think that the commission staff should hear, we encourage you to send it directly into them. So it's also coming from the public, and they also have a record that you communicated with them. And we leave it up to your discretion whether or not you want to copy ENNA. And then obviously, if you are able to appear at the public hearing, it is beneficial to have a lot of people there when we can. Unfortunately, it is on 6 o'clock on a weeknight, so it's very hard for people who work or have obligations at home with children or aging parents to be able to do this type of thing. But you can also participate via Zoom. And at a public hearing, they typically will alternate between speakers from someone who's actually in the room and then over to someone on Zoom, and then alternating back and forth. The key is if you intend to present any technical information on your own or any factual information that you think the commission may not already be aware of, or if you just want to verify and confirm what they may have heard that you want them to know about, you can certainly do that. But one of the best influences you can have in talking to the commissioners is using your personal observations and what the impact will be on your quality of life and on your street, etc. Keep in mind that commissioners, although they are not elected officials, they're all appointed, and so they all must live in the city of Norwalk. So they live here, many of them work here, they travel the same roads that we do, they patronize the same businesses that we do, they go to the beach like we do, etc. And so the idea is that they have a great understanding of the impact of these things on the community, and that they should be sympathetic to folks who are directly impacted. We, of course, you need to give your name and where you live. It's important to, when you're talking about the impact on you, to be able to tell them where you live. It's helpful to tell them how long you've lived there. In the case of, someone who may have lived here for 10 or 20 years, or if you just got here last week and you're concerned about this, but then to be able to articulate how this will impact you. For example, if you live on Myrtle or Fitch or Strawberry Hill or Triangle or Bridge or any of the access roads in and out of this property, you already observe the number of vehicles and trucks and buses and all other types of traffic that's on the road. And so it's helpful for you to talk about what you think the impact will be for your quality of life with noise, pollution, traffic congestion, safety, especially if you have children that are walking to and from school, any kind of sensitive population that's part of your household, for anyone with medical conditions, seniors, young children that could be exposed to additional exhaust and pollutants, and also, of course, noise as well. And this is really important because as you're telling them where you live or where you work or what you do in the community, they'll be able to visualize where you're talking about and what the impact would be to you and your neighbors in that area. And it's important. It's the type of thing where you're not going to have to go in there with facts and data to say, there are 16 cars per hour on my street and this number of trucks, and this is how fast they go. It's just enough for you to be able to articulate what the current situations are. If this is the type of application that's going to exacerbate a bad situation, and as importantly, for you to be able to articulate if you have a pretty decent quality of life and you're concerned about this application degrading that in any way. And also, it's a little harder to do this without some facts and data, but you can also express any concern that you may have about your proximity to either this parcel itself or any of the vehicular routes in and out of this parcel, and how it could in the future actually impact the value of your own property. And again, and to appear at the public hearing at 6 o'clock, you can either come to City Hall at the council chambers on the third floor. You'll be able to speak there, or you can log in via Zoom at 6 o'clock and be able to raise your hand at the appropriate time to express your concerns there. Okay. So that's kind of an overview of where we're going for Wednesday night. One of the things that we did in the weekend newsletter is, I'm thinking now, if I did do this, I'm sure I did. In that newsletter, there we have posted the videos for both of the prior hearings. The May 8th hearing that contains the complete presentation of the application from the applicant, including their traffic engineers, their civil engineers reviewing the site plan, and what is by all accounts a fairly inadequate environmental impact report as well. The May 15th hearing was primarily to hear from the public, and we opened up that meeting with a compelling testimony via Zoom of both the air quality engineering expert and also the traffic expert as well. So you can listen to that. Their reports are also posted on the city website, so you can actually read them. And they're fairly easy reading as well. And then they went into public comment. So if you have some time between now and Wednesday, we suggest you grab some popcorn or with your dinner, be able to watch those videos, and you'll find them helpful in addition to reviewing the document. Okay, so we will, let me take this down here. We can go back to it if we need to. Before I do that, before I close out this PowerPoint, just want to say, so you can jot down our next meeting, unless something continues with Norden and we need to meet again as a group, will be our regular Monday meeting at June 17th. We may or may not have some guest speakers at that, but we'll keep you informed on that meeting. We can take some questions or comments for anyone about the application itself or about the public hearing. If we'd like to focus on that tonight, if time permits at the end, and you have a new topic of quality of life or land use issue in East Norwalk, we can certainly talk about that. I know there's been a lot of talk about East Avenue, our watch list. And as many of you have heard, and actually I just found out myself because I hadn't been over there, that the demolition of Jimmy's Deli is apparently complete. And if we have time permitting, we can talk about some of those items and also Cemetery Street. Okay, Charles.
Judy has her hand up.
Okay, we'll do Judy and then chat.
As usual. My question, there was some mention of using Beacon Street for something at the hearing. I don't remember what that was, but I have comments about using Beacon Street, if that was what they were talking about.
Yep, and again, these documents are on the city website, so you can actually see the map of the parcel itself and then all the peripheral streets. But what they're suggesting is that they're going to be designating several different routes for vehicular and truck traffic coming and going from the parcel. I think one of their ideas is that not necessarily everyone would be heading to I-95, and depending on which direction cars and trucks might be coming to and from, they would either be going on Strawberry Hill to Beacon, Strawberry Hill out past the three schools out to US 1, Strawberry Hill to Fitch, and then also don't forget Norden out to the Triangle Bridge, Bond, Howard, Winfield, that area as well. Now, I do want to mention something about that route, Judy, before we talk about Beacon. The route that goes out to Winfield, just to remind folks, the bridge that goes, the highway bridge that goes there in Westport was not required to be raised or comply with a 14-foot passage for large trucks, although the DOT insisted on making the East Avenue Bridge comply with 14 feet so trucks can get under there. Ultimately, when the East Avenue project is complete, the road will be modified so that trucks can get through there. So we have a lot of questions that always come in about Winfield, about concerns about all the big trucks going to and from there because it's easier getting on and off 17 when 16, 15, and 14 are the disaster we know they are. But to that end, only relatively smaller trucks, delivery trucks, can take that route. All the rest of the trucks that don't fit under that bridge will have to come through East Norwalk, either up Strawberry Hill, down Beacon, out to East Avenue, or East Avenue down to Fitch. When they do that, by the way, I just made a comment today at the Traffic Authority meeting that it may not take these vehicles with the workers and the smaller trucks. It was not going to take them long to figure out that if they go down Myrtle, when they get to the end of the Myrtle, there's not a no turn on red there to get to the highway. Whereas when they go all the way down to Fitch and they come down there, they do have at least a period of, they have to wait for the green arrow there to do a turn on red. That may change in the future, but that's what it is right now. Judy, I just want to add one more thing on Beacon and Norden and Strawberry Hill. One of the suggestions for mitigating any possible traffic congestion and gridlock there is that the city's transportation, mobility, and parking and the applicants, I think both together, are suggesting that they do hash marks for don't block the box. But we know two things about that they're not effective. Because often by the time drivers realize that's a don't block the box with hash marks, they've already crossed into it due to the traffic ahead of them. But also, the other thing is that for the most part, at all the intersections where those are needed, it's also not enforceable. The police department, when we went through this with Olmsted Place and also North Avenue, confirmed to the city that essentially there's no safe way to pull over cars that have violated the don't block the box, because you're creating more of a traffic hazard and gridlock and congestion by attempting to pull them over. There's just not a good place to do it. So the solution there to try to not create that situation is one that's essentially not going to work.
Well, I have two more comments about Beacon Street and the traffic in general. Has the traffic report been cumulative with the traffic from the nursery and the DOT operations?
But they would have taken into account the original version did not have the nursery in there, but because it is an existing use at the same time this was all happening, then they did have to factor that in. They didn't have modeling to use for a wholesale nursery, so they lined it up as best as they could with what's called the ITE standards for how traffic counts and traffic impact are kind of industry-wide. It's what all the engineers use. They also factored it in based on the actual feedback from the nursery themselves, based on what their operation was when they operated down in South Norwalk. That nursery is actually a matter of a relocation because they had to move out of there to make way for the new school. So it was an existing operation. So they did have some data on the number of trucks and cars that service it and go in and out. It's also a wholesale nursery, although they did say that they have a small percentage. I want to say it was 15 to 20% maybe. That's actual like retail, like for consumers, but the bulk is for wholesale. So that was factored in. What we're not sure was factored in at all, though, is Avalon, the Halstead parcel, because essentially the access to and from there ends up being a private road that leads back to the apartments. The third thing on that duty is that in factoring in potential future use, because the city does like to see what a potential build out of most, if not all, of the rest of that parcel would be. The city unfortunately allowed the applicant to factor in a model for future build out of Norden Place by saying that it's likely to be a 300,000 square foot data center. And for those of you who have been following along with this, you will have already heard us say, and our traffic expert has confirmed it, that the least impactful traffic and person related use that exists is a data warehouse. So we have voiced our opposition to this being the one use that they're using to when they consider what the future use could be on there. I'll add another point to that just because I'm thinking about it. ENNA specifically asked Steve Kleppen twice, under what conditions could the MTA or the owners of the property expand upon the MTA use of this parcel to take more space both inside and outside the building. And he has articulated even to the commission that he's not really sure of what the process would be, except that he's confident it would have to come back to the commission. I'm not so sure about that. And so we've raised that as a valid concern that the commission should consider, while they're thinking about approving this thing. Okay, Charles, we have another hand up or a chat?
Yes, Elizabeth has her hand up.
Hi, Diane. Elizabeth Kenny from Triangle Street.
Hi,
have written a
Elizabeth.
couple of letters and am, first of all, want to say thank you so much for everybody in ENNA for all of your hard work about this. I'm embarrassed at how uneducated I have been prior to hearing about this, but having heard about this and having paid attention for the past couple of weeks, there's so many things. Number one, in the conversation tonight, it's called a transportation maintenance facility versus transportation maintenance terminal. I think that it's very important to have the vernacular correct. A terminal is not a facility. What is allowed under P&Z is a terminal, not a facility. One of the things I spoke in front of P&Z at the last meeting last Wednesday, I brought to the table the definitions that MTA utilizes. And I know, Diane, you and I spoke specifically about the fact that Norwalk P&Z does not define what a transportation maintenance terminal is, but the MTA does have definitions about what specific facilities are and terminals are. And it is interesting that since we, the city of Norwalk, doesn't have definitions, it is smart to go to the MTA and say their very definition is not what we allow. And I think that's a very good classification. So anybody that's planning on talking this week, they should bring that up to say, I
agree.
Just backing up one step, anybody that's talking, listen to go back and hear the hearings that already said and say, I agree with Elizabeth Kenny when she said this, and I expand upon that. When we're talking, build upon the conversations that have already been brought to the commission. So anybody that wants to talk about that, come in and say, the MTA, this is the MTA definition. They do not allow this. Even though we haven't defined it, they don't define it. So we should err to their definition about this. On a separate note, on the, I was going through the zoning allowances that were approved on 10/19/22. And section B, principal use and structures. Number 1, transportation maintenance terminal is subject to review and approval of an environmental impact report. So they very, very clearly say in the P&Z rules that it's about environmental impact report. One of the notes when Attorney Suchi spoke on May 8th, she talked about the impact is there's, I believe, 6 guidances that are allowed. One of them specifically is adjacent properties only, not the neighborhood at large. So anybody that is specifically adjacent to the property, get up and talk. We need you. We need you specifically to talk about this because you are the people that are allowed specifically by P&Z to scream about this. I live at 3 Triangle Street. I'm 500 feet from the site, but my opinion really doesn't matter based on the actual law. We need the locals to really get out and talk about this. I'm here and I'm ready to fight. Like I've told Diane the other day, put me in, coach. Tell me what I can do to get through this. But
Thanks, Elizabeth. Yeah.
Thank you.
Those are actually great points, and really, I'm remiss. I should have mentioned that the most weight always would be the neighbors that abut or adjoin or adjacent to a particular property. That really comes into play in terms of any possible appeal, because only those residents would be considered to have legal standing as being aggrieved by such a decision. However, and that's a good point, and they, that's really what will be taken into account. So we do encourage the folks at 11 Norden and 8 Norden, and the parcels that are directly across the tracks, to be able to get together as many of your neighbors to email and to speak at the hearing as well. And then secondarily to that, the impact of folks, as I said before, if you happen to live on the route or you are specifically impacted, say by the route your children take to school, for example, that's important. Before I want to forget, and everyone I want to say is doing a fabulous job for the people that have written letters and spoken and participated and helped in sending research. But there are 2 letters, and I will call out the folks here. There are 2 letters. You'll see on the city website, you'll see little batches that say letters from the community. They don't say letters in opposition, but I don't believe there's any letter in support of this thing. But I would highly recommend that you read those letters, but that you read 2 letters in particular, which are just extraordinarily written, actually 3 of them, and really bring out a lot of the facts and data and things that the commissioners should be questioning, and we haven't really seen them doing that. So that's Christina Olson's and Elizabeth Kenny, and also oh my gosh, the other name is completely escaping me right now. I'll have to oh my gosh, I'm having a brain freeze, but I will get it before the end of the meeting. But I would highly recommend that you read those letters, particularly those 2 as well. Folks, please don't be shy. If you have questions, even if you think it's something silly, or if you're hopping on tonight, this is the first time you've heard about it, and you need like a quick overview or need to know how to reach out to us to I may as well say that now too. So to reach East Norwalk, the easiest way is to email into us, and that's info at eastnorwalk.org.
Okay, we have Daryl's hands up.
Hi. I just had a question because it occurred to me when I was trying to watch all the stuff going on before. at the meetings. Has anybody taken into account the fact that schools are used more than just during the day, they're used at night? The other thing is, I would assume, having been an educator for 38 years, that what will happen is that more and more parents will see this as a dangerous road. And so they will be driving, more and more parents will actually be driving their kids to school, which will actually increase the amount of traffic on Strawberry Hill. And I wondered if that was taken into account at all.
Great question, Carol. And I would just say in your capacity as having been an educator, it would be great if you could share those thoughts with the commission as well, one way or another. Yes, on two counts. One, it was raised at the public hearing, and I believe in our traffic analysis as well, but at the public hearings, that the school hours are not strictly a start and end time. There's after school activities. There's things having to do with transportation to off-site activities as well. So that was factored in. Another important factor that came up that I hadn't realized until our traffic expert mentioned it is when he was doing the analysis of the applicant's traffic conclusions based on their work hours and when people would be arriving to the site in the morning, when they would be leaving, when they come back in the afternoon, and when they leave in the afternoon. That window of time was so closely related to the school hours that just a shift in the hours either way would dramatically change these numbers to how many either personal vehicles or trucks would be on the road. In one case, it's just a 30-minute shift. Now, even if the MTA wouldn't do that or historically hasn't done that, you also have the factor of whenever you have shift workers that need to be on site to be dispatched or to be within the facility itself. I have worked in my careers for a number of these types of industries, and I can tell you that the main goal, if you're running late, is to get there as quickly as you can. And so what you find is, basically reckless driving. And you'll see it with people literally pulling into these facilities at, 3 minutes to 7 or at 7:01 if they're supposed to be there by 7. The other thing is people make, the other group of people are the ones who leave early and just kind of mosey into work because, sometimes who wants to get there particularly early to work? But on the back end, you have people who are anxious to leave work at the end of the day. And so you have the same phenomenon on the back end. But we are concerned about how close these hours are to both, Carol, the actual school hours and also to the impact on school activities. The other thing that we don't think they took into account is I think this Norwalk High School project is a multi-year construction project. I haven't had a chance to look that up yet, but I don't know that they factored in all the trucks and activity around at school. Presumably all the materials and trucks and everything would be coming from East Avenue and the highway as well, for the most part. Maybe we could talk offline as well, because the other thing that occurred to me is I also find that this has been a national debate, and I think in some ways, local communities, there's always been a lot of talk about changing the high school hours around what the hours are that high schoolers should be getting up and going to school. And I think if there was a shift in that down the road, that could also put them kind of in the target. But if you could send those concerns in, I think it would be really good.
Okay, I also think it's important to note that the applicant has mentioned some night shifts, which would go pretty much all night and might overlap with the coming and going of the day shift. So I don't know if those car vehicles were counted in the traffic study for those days or what that would entail.
Yeah, and exactly where they overlap, if it's the, like, say, 11 to, 7 shift or something like that, where they overlap. They did do a supplemental traffic study that included some of that data. I remember when they first filed their application, they said this was a strictly daytime um, operation, and they just put in a caveat that if there were any kind of emergency track work or something outside of their control, that they might have some very limited after hours or weekend or holiday type activity. But then they came back and did the 180 on that to say, in fact, they would have many weekends where they would have different types of workers there on the weekend. And in some cases, I'm not sure if it was Christina, Elizabeth who raised this, or someone raised the point that they don't actually tell us when those types of weekend activities could all converge. And so we could end up with virtually every weekend of the year having a substantial amount of people there. In terms of the night shift, I noticed that at least one of their other facilities in Stamford has 24/7 security at the site. And when we asked about that, they said no, they had no intention of doing that at Norden, but that they felt that having a night shift in itself would be a security deterrent, because there would be lights on and there would be cars there and there would be activity there. And that may very well be the case, but one of the other concerns we have is whether or not they think these lights on all night will be a light pollution for the neighbors. They contend that that won't be. We're looking to get Norwalk to join with some of the other communities now who are subscribing to what's called the dark sky compliance. So to not have our skies lit up, especially when there's a bird and a wildlife migration patterns, because I won't get into that now, but it just wreaks havoc on what happens to bird migration when you have these types of lights on all night. Thanks, Charles. That was a good point.
Okay, Christina wants to give it another try here.
Okay.
Can you hear me now?
Yes,
Yeah.
we can.
Yes, sorry about that before. And Diane, thank you so much for leading this fight. I have a few specific questions. When it comes to actual violations on the existing Norden property, I mean, I know that RV vehicle is still there. It was there 2 hours ago. I'm sure it's still there now. Are there any like actual violations that they have right now? Like, is that in violation of something? Like, is there paperwork on file with City Hall that they are not a tenant in good standing, that they have this RV violation, like that they're in violation of something?
Yes. So yes, there is. It is related to, well, it was related to 2 factors at that time. One was the illegal RV, and the other one was illegal car parked there, which may or may not be a stolen vehicle, but because the car is parked on private property, there's not a whole lot you can do with that, although I think that may have subsequently been moved. The RV is a different factor because that's considered someone living there in the RV, and would then be a residential use on the property, and it calls into question the use, the vehicle, health violations, etc. We would have thought it'd be cleaned up a long time ago, but it is still there. Here's the interesting point with that, is that the way the zoning regulations work is that the zoning permit itself, the whole application can continue to be considered while there are violations on the property, even if there were multiple, even serious violations there. But what happens is that the zoning approval cannot happen while there are zoning violations that are still on the grounds. Now, you would take that to think that RV must be gone before they vote on this on Wednesday night.
Yes.
However, let me add another little trick into this. And we may as well talk about this too. The commission can approve applications that then have conditions on them, so that their approval is subject to a list of conditions. Sometimes that list of conditions is very long. And we contend that if you have more than a handful of conditions that are kind of boilerplate things, and maybe 1 or 2 other things that an applicant has to clean up, that aren't serious, that's okay. But what ends up happening is they'll approve applications like this, and they could include a condition that says it's the actual then zoning CO or the zoning permit even cannot be issued until all the violations are cleared up. But what happens is they've approved it. And so then it's left to then go back, and very often it's the public then saying, this thing needs to be cleared up, and why are you issuing a permit for this? So I hope that that's not the case, considering this RV, and that the staff holds the applicant's feet to the fire to say that there wouldn't even be a vote while this violation exists. I have a feeling, just with the history of how this operation has worked in the past few years, that they won't do that. The other thing that some residents have just begun to raise, mostly coming out of, thanks very much to the folks over in Halstead, is the fact that we'd like the commission to take into account that the property owner hasn't been a good corporate neighbor at all. And so I think that it's right to be able to take into account past history as a indicator for future actions by, or lack of actions in this case, by the property owner. There are potholes all over that property. Maybe their own vehicles are impacting, but potholes collect rainwater. Rainwater contributes to mosquito and rodent activity. There's also been poor maintenance of vegetation and trees on the property. They have not maintained the signage properly that they're responsible for in terms of stop signs and other directional signs. And there were a number of other examples that residents at Halstead have pointed out in terms of the past performance of the property owner. And don't forget that, again, it's the property owner, Norwalk Center LLC, and presumably their future partner, Beneroff Properties, the folks who applied for the warehouse distribution center. They will actually be the property owners. We haven't heard that anything other than a long-term lease with the MTA would be in place. So we haven't heard anything about a sale. And so we can assume that the same owner of Norwalk Center LLC for 10 Norden Place, the whole structure, would be the one who would be responsible for not only clearing up that current violation, but also making sure that the property isn't used, illegally in some other way down the road.
So speaking of historical performance, there's that document online that's from the Connecticut Department of Environmental Protection regarding the emissions from the Norden furnace from about 10 years ago. The furnace was emitting too much NO2 into the air. There were fines levied on to Norden Place. They didn't pay it. Then they came back with civil fines because of those unpaid fines. And what I don't understand from the environmental report from the MTA is, has that furnace been revamped, replaced? Is when it runs, are those emissions in line with the deep today? Because 10 years ago from that document, they were in violation.
That's actually a good question, Christine, and I don't have an answer for that. I think we actually need to get that into staff, because they would have to take into account, as far as I know, any kind of violation on the property. So if they're not in compliance with the orders there, and they still have outstanding fines for non-compliance, then we do need to bring that to their attention if we haven't already done that. I'm not sure if someone already sent that in.
Well, that's
the other thing we have is the consent order in terms of the ongoing monitoring of the chemicals that were the pollutants that impacted the private wells across the way as well.
Right,
and that has to continue.
Well, that the company still pays for the groundwater testing, but again, in the environmental report, there was no mention of what would happen, because when I read through the application, they want to dig up, regrade, repave part of the lot. And there was no mention of how that would impact the chemicals that are buried in the soil.
Yeah, I think that they spoke about, and it's one of the outstanding questions that we still have going into them, because they weren't really specific about exactly what they need to do there. They mentioned like reconstruction and construction work there to ready the site. There weren't enough specifics for us to satisfy us on exactly what they're going to do. I know that what they said they intend to do is to be able to manage any of that in a manner that the portion of it that would be that could be disturbed, they wouldn't be disturbing the cap on it or doing anything to that extent. That's a good point as well, because who's left to actually police that? And do we, I'm writing this down as we're speaking, do we actually have the complete report on what they need to for construction of the parcel itself, and then for the parking and the storage and everything? And I don't think that we have anything about what they intend to do on the inside to retrofit the inside of the facility as well, and what impact that could have. Speaking of which, I want to bring up another technical point that we have also asked the lawyer we've hired for ENNA to consider, is that had this site, speaking about the definition of transportation maintenance facility or terminal, when you take a look at the use of this property, it really lines up more with more of basically a contractor storage yard. And when you look at the requirements for those, for how much of the parcel can actually be used to store materials outside, and how high they can go, and how they have to protect chemically treated materials on site, it would suggest that the applicant and staff took every measure they could to be able to classify this in a manner that didn't require a special permit. Now, is that illegal for them to do? Probably not. And the fact that they made up a whole new use in order to get this in, probably not. But there may be an argument for spot zoning, which they can't do, which is to come up with a use in a zone that's essentially wouldn't be allowed anywhere else, but is for this particular applicant. And so this whole issue of sidestepping the special permit, which would have had much more benefit to, err on the side of the caution for the residents than the applicant, needs to be called into question.
So
and that does go back to exactly what they think they're going to do on that property for where the equipment and the trucks are going to be stored. And is it really a commercial? The other definition that this would have fallen under is commercial vehicle storage as well, because of their trucks and equipment there too.
So that leads into my next question. I did email Steve Keplin on Saturday. I've yet to hear back of exactly how many cars will be in the storage fleet, meaning he's rattled off, or Attorney Suchi rattled off, the 13, diesel engines, like the buses, the excavators that will be there. But unless I missed it, and that's what I'm asking, how many of those fleet cars will be there? Because the way I read the rules and regulations is, I'm going to assume we could have a storage yard under 20,000 square feet. I'm going to assume we could have commercial vehicles under 20,000 square feet. And who's regulating to make sure that they stay within 20,000 square feet? Right.
Which was the threshold then for which would have required the special permit as well.
Exactly.
I've also been checking periodically to see if answers came through on that and other ones ENNA sent. And I can tell you as of today, crickets. So we'll see what tomorrow brings there.
Because you would think they would have that number. We expect to have between 30 and 40 vehicles on site. And that would go to their pollution report as well, or the environmental report as well.
Right, exactly.
Okay.
And then to be able to articulate how much of the parking facility or that whole side facility is actually split up between the storage and the vehicles there as well.
All right, thank you. And then I'm going to drop off, but if you could just talk a little bit about the difference between a terminal and the facility.
So the main point there is one is that there's no definition within the zoning regs that
Right.
existed before they did the industrial zone rewrite. And then they put in transportation maintenance terminal, I think is what went in. In terms of what's new in the new regs, this is not in the regs that went in February 19th. This use is not in the new regulations. So it wouldn't have been allowed under there. In terms of whether calling it a facility or terminal, I can't really speak to that except for what we were talking about, where the MTA has its own definitions for that. I'm more concerned with the fact that even the commissioners didn't ask staff to define what a transportation maintenance terminal is for this location. How do they know if it meets the definition? Part of the problem with this, Christina, is that because Steve Kleppen made up this use, but said that it's allowed at the parcel as a site plan review only, that there can be no question about the actual use. What the commission is considering is the site plan for the use. Do you see what I'm saying?
Mm-hmm.
But it doesn't mean that we can't question the definition and be able to say to them, this is more than just a matter of semantics, because if you don't define it, then how do we know how this thing can be expanded? And how do we know what the MTA has in mind for what they're going to use it for versus what you guys are calling it? Is that what you're talking about?
Yeah, it is the same subject that, Elizabeth brought up.
Right. Yeah, exactly the same thing. And I think it's fair to say, I think even to say to Steve Kleppen, because when he answered me on it, he basically said, we did not define it, but there are also a number of other uses that aren't defined. And I'm not sure. I mean, it just falls under do two wrongs make a right? I don't understand the logic. I could see if this thing had been a use in there, say, since 1920, and no one had ever defined it, and subsequently didn't even occur to them to define it. But for Pete's sake, if you're adding a brand new use, then wouldn't the first thing you do be to define the use and have all the specifics of what the use is? If you look at how they jump through hoops, and maybe they had to, but for things like vape shops and cannabis shops and beer, not beer things, whatever you call the brewery type things, and some of the new uses that have gone in, like boutique manufacturing and things like that. As each one of those uses got added into our zoning, they were added in with definitions, and sometimes the zoning commissioners themselves spent hours over definitions and semantics and taking words out and putting words in so that it was very clear, not only to the community, but the potential applicants for the use of their land, so that they were very clear on what the definition was. So very bizarre, brand new use, and nobody bothers to define it for anyone.
Yep. Thank you very much for your time.
Thanks, Christina. Thanks for hopping on.
Diane, there was one last question about who owns the property.
Okay, so the property as of today is owned by an entity called Norwalk Center LLC. They've owned it for quite some time now. It appears that there is possibly what's called a contract purchase that may be happening between Norwalk Center and LLC, and some sort of an agreement or sale or partnership with Benaroff Properties. Benaroff is the big property and development company that first came looking to buy the parcel for use for the massive distribution warehouse center that we have since been told by very reliable sources absolutely was going to be an Amazon warehouse, despite everything we were told prior to that. But as of today, Norwalk Center LLC owns the property. And when you look at the documents online, you'll see, again, the applicant is not the MTA or Metro North Railroad or the DOT. The applicant is the property owner. Okay, I think we have Elizabeth has her hand up. I don't know if somebody else had
Hey,
one
Diane.
before.
Sorry, Elizabeth again. Elizabeth Kenny, Triangle Street. I just wanted to do a couple of notes. In Elizabeth, in Attorney Suchi's address to P&Z on May 8th, she gave a little bit of a historical perspective on the property. And she talked about that it was originally 80 acres, and in 2006 they sold off 40 plus acres to build the Avalon building. Then there were 33 acres, and in 91 it was like there were multiple levels of changes to the industrial usage and the P&Z usage to the building. In 91 it was restricted industrial,
Right.
And that was the classification until the change in 22.
Right.
And in 22, it was classified as industrial number 2,
Right.
which I'm not exactly sure what the vernacular is, but obviously people fought to change it. And the changes were adopted in December of 23 that
Right.
went into effect in February 19th of 24. This application went in on February 14th, 24, 5 days prior to the new P&Z regulations being adopted or being affected, but they were adopted months
Right.
before this application went through. So it's
Right.
actually interesting, and the community needs to understand that the parcel was never classified as industrial number 2. I mean, it might have been back in the 50s, but from 91 on, it was not. And for a very short blip of time, it was. And the community said, don't do it, don't do it. And the P&Z said, okay, you're right, we're going to change it back. But this application came in like right under the wire. And here we are trying to fight it. Now, Go ahead. No, Diane, please speak.
Oh, yeah. So what I was going to say is, what people may not know is, so when that was going on, the industrial zone study is what was going on in 21 and 22. And during that study, they were looking at all the industrial zones in the city. One of the things that the consultant that worked on that study said is that when you're looking at all these parcels, there are 2 groups of parcels that are so unique that they really require their own special studies to determine what are the best uses for these areas and what is it that the community really wants to see them be in the future. One was the industrial waterfront, which literally are the industrial parcels along the river and the waterfront. And the other that they said is Norden, literally the Norden parcel, because it is so unique in terms of its history, its placement, the size of it, etc., that the city should only zone it as industrial 2 until such time as the study is commissioned and funded and completed, to then determine how it should ultimately be zoned and used. Now, it could have been zoned industrial 1, which would have had much more intense, higher levels of manufacturing and industrial use. Instead, we were able to at least get it designated as industrial 2, which is less impactful in terms of all the uses. Having said that, there were still a number of uses that Steve Kleppen refused to take out of industrial 2 for Norden. One of which is, well, actually, I can tell you some of these if I could read them, but things like there were like petroleum processing sites, there were Then you have the Transportation Maintenance Terminal, which he actually added in. There were passenger vehicle assembly facilities, warehouse and distribution. And so ENNA, when we spoke up again about what we thought should be in the industrial zones, and we spoke specifically to Norden, we begged Steve Kleppen and the commission to take out some of the more objectionable uses from Norden, and or at least put a moratorium on them that said these applications cannot be accepted while there's a moratorium awaiting the special study that the consultant said should have been done. So not only didn't that happen, or actually, to be fair, a couple of the uses did come out, but what ended up happening was that a couple of uses went in, and one is the Transportation Maintenance Terminal. In fact, I'm sorry, I printed this thing out so small I can't read it, but I can provide this later for the ones that went in. When that use went in, it went in as a site plan review, which is what I was talking about earlier, instead of a special permit review. What he did put in a special permit review, which I think would have been even less impactful than this, for example, are an animal care center, a commercial vehicle storage, which may have just been, something small for contractor vehicles, a municipal utility plant, which would be highly unlikely to happen, especially as the third taxing district is our own electric district, and we already have the facilities, two of the facilities here, so that wouldn't have even been likely. And the other one is warehousing, and that would have had a special permit use. And then also historic preservation bonus for dimensional standards. I'm not sure what that's for. So all of those went in requiring special permits, but this Transportation Maintenance Terminal did not. So not only did it show up when nobody asked for it, it showed up and people actually asked to have it specifically removed. The same points that we're making today were the same points that we made then. It served a regional base and has no relative benefit directly to the Norwalk community at all, that it shouldn't be there. And, at the very least, that it should have required a special permit. So when you look at the history of this from a restricted industrial to industrial 2 in that short window of time, and then you jump over to the complete zoning rewrite where they take this out, that in December of 2023 and in January of 2024, that this application was already ready for prime time. They had done traffic studies months before. For any of you that came to the tour on May 6th and also listened to the applicants at the May 8th hearing, you heard both the owner at the site review and you heard the applicants themselves at the hearing tell you that they have been working with city staff for years on this. And so they were not just talking about working with city staff in terms of this parcel. Clearly, they were talking about working with staff on this actual application. And so that's why we concluded that everything that was written and ended up in the industrial 2, in the industrial rewrite, was specific to this application, written right down to the specifics that would allow it. And I think that they crossed every T and dotted every I. I can't really elaborate in the public meeting, but I can tell you that though they rarely make mistakes, they may have made a couple of fatal flaws in here. So we'll see how that hashes out over the next day or two. I'll also want to say something about appeals. I'm sorry, I know we're going over, guys, and please hop off. Don't feel like you have to be polite and stay on. But let me say something about appeals when it comes to this type of application. There could very well likely be an appeal either way that this goes. If the commission decides to take all of the facts and data into account and deny this application or deny it without prejudice, my bet would be, knowing the applicants and their attorney, is that they would turn around immediately and appeal on any number of grounds. They would especially do that if a commissioner happened to, how can I say this? If a commissioner misspoke or even deliberately spoke and provided what they used as justification to deny the application, and it wasn't a factor under which they could do that, that would be an immediate grounds for appeal, amongst some other things. On the flip side of that, if they go ahead and do approve this, there's a fairly decent list of items right now that we've compiled that would be reasonable grounds for an appeal. The issue that comes with that, again, as I mentioned at the beginning of the meeting, is that only residents who have or other stakeholders that have legal standing can actually bring the appeal to the appellate court. And that is generally abutting, adjoining, and adjacent properties. And the adjacent properties would have to be literally within 100 feet of the parcel. It doesn't have to be within 100 feet of the portion of the parcel that they're using. As we've read the law, they have to be within 100 feet of the parcel. And since Norden Place is actually a pretty big parcel, then anyone who qualifies as 100 feet would qualify. The issue with that is that you need people who are willing to put their name to be on an appeal. Not that you really have to do anything. The lawyers kind of take over from there. But it does require the community, the appellants, the actual abutters withstanding, to be able to, and the community to help to support or to raise the funds that would be necessary to bring an appeal. And I can tell you that that's generally time consuming and costly. But I would also tell you that we should cross that bridge when we get to it. The only caveat I'll add to that is that, not unlike many of the statutes in Connecticut and across the country, to be fair, almost all of the time clocks that work with the legal issues of zoning work against the residents. They're all in the favor of the applicants. And so should residents decide to appeal, there is a very tight window of 15 days only to do that, 15 calendar days. And it's from the time that they post their approval decision in the local newspaper. In recent years, we have found that Steve Kleppen has the approval notices already completely written up. All they need to do is fill in the date and send it to the hour. We had one that actually appeared in the hour the next day. Before, in years past, it could be like maybe the next week it would be in the hour. So you had a little bit of time on that, that ticking time bomb against us. But my guess would be that if this gets approved, if it goes to vote on Wednesday and it gets approved, that notice could certainly be in the hour by Friday, I would imagine. And that 15-day window starts from there. And it's something that once you miss it, it's unforgiving. We learned a very hard lesson on Cemetery Street, with a sad tale about that, but it is unforgiving. And even though a court may be sympathetic and feel real bad for you, there's almost nothing you can do when that window goes by. So, okay, I think, Sarah, do you see any other hands up or anything in chat we need to address?
I don't see any others. I'm just going to double check again here because I missed something before and I don't want to miss it again. No, I don't see That's it.
Okay, so two things. Check your emails from the weekend. It has the information and videos, the link to the city website. It also has the address for Ski Kleppen, so you can get your comments in. Typically, they need to be in 3 hours prior to a hearing, so please have those into him by 3 p.m. The other thing is if anything urgent comes up between now and then, because the applicant can keep dumping things on us at the last minute, I will make every effort, reasonable effort that I can to try to turn around an email. If people want to stay on for a few minutes, I always volunteer to stay on a few extra minutes. If you're not inclined to speak in the big group and you want to talk about this or something else, I'll hang out. Otherwise, please email in with any questions or any help that you need. It's info at eastnorwalk.org. And thank you all very much. I hope that we covered enough for you to understand what's going on and care enough to get involved and to at least speak up a little bit.
Thanks, Diane.
Thanks, everybody.